High Court today has come down hard on the Service Tax Department for arresting Make My Trip President M.K. Pillai for a tax outstanding of 67 crores. Ashmit, who was in court when the judge delivered that order, joins us now with the details. Ashmit, it's a scathing order against the taxman.
Indeed, the Delhi High Court has no kind words as far as the conduct of the Service Tax Department is concerned. And it's important to spell out the facts of the case here. It's important to point out that in January of 2016, M.K. Pillai, who's the VP Finance of Make My Trip, was arrested by the Service Tax Department, essentially on the suspicion of tax evasion. There was no show cause notice that was served. The assessment proceedings were not complete. And in fact, all these factors have worked against the Service Tax Department in an order that is highly critical of the conduct. Now, the Delhi High Court goes on to say that the actions of the Service Tax were in fact extreme in nature, were coercive in nature, that they appear to be whimsical, not thought out. The procedure of law was not followed. It was patently illegal. Furthermore, the Delhi High Court clarifies that mere suspicion at this stage cannot be used as grounds for arresting parties, for invoking the provisions for arrest. Furthermore, the Delhi High Court goes on to add that at this stage, at the stage of the arrest, the completion of the assessment itself was not complete. The demand had not been determined. At this point, only a suspicion existed, and that adds further ground as to why this arrest was illegal. And finally, there is a word of caution being put in by the Delhi High Court that in exercise of these provisions, one has to be wary, one has to be circumspect, one has to be carefully thought out in terms of taking such penal provisions, as such measures are ideally adopted against habitual offenders and not against assessees who have a proven track record. So the Delhi High Court being very critical here and adding clarity on a much needed issue.
And joining us now to discuss this further is Mukesh Bhutani of BMR Advisors. They were, of course, involved in this case. So Mukesh, congratulations to you and your team at BMR as well. But what does this now mean, and what kind
and all the principles have been laid down by the High Court, which is really emphasizing the intent of the law that without a show cause notice, you can't straight away go and arrest a person merely on suspicion for evasion of service tax. I think the limited issue over here was whether Make My Trip as an online portal is providing a service which is a hotel services, or is it a tour operator? Because the abatement provisions for a hotel services and tour operator is very different. So here is a case of a taxpayer who has been regularly filing the tax returns. The service tax compliances clearly show that they are a tour operator, which is they're providing these services online. And just based on certain surmises and assumptions that the investigative agencies made, they carried out the most tough action, which is arresting the person. I think insofar as legal principles are concerned, clearly the High Court has said that the provisions for arrest, which have been prescribed in the law, clearly prescribes that there should be an inquiry, there should be an opportunity that should be given, and then only after the circumstances you carry out an arrest, that too after raising a demand and going through the entire procedure of law, and that procedure was clearly violated, and they have said that it really violated the fundamental principles of a citizen of India, because they have held that this is constitutionally not correct and breaches the fundamental principle of the concerned person who got arrested.
You're right, and Mukesh, as the Delhi High Court has clarified that it's not against the provisions for arrest, but it only seeks compliance with the procedures that are laid down in law. But if I could talk to you about the larger issue here, and that has to do with Section 91 of the Finance Act, which allows for willful default of service tax to be deemed as a cognizable offence. But given what we've seen happen in this particular case, and if I were to extrapolate that forward, as an added layer of protection against arrest, should the government consider making the offence liable for arrest as only non-cognizable?
Well, there are many provisions in the various statutes which makes offences non-cognizable. For example, non-payment of provident fund or non-payment of taxes that have been withheld. The underlying philosophy is that the moment you deduct tax or you deduct a provident fund, you become an agent of the government and you owe that amount to the treasury. And if you're going to be starting funding those operations, then clearly it's patently illegal. I think here it was a case of mere surmises. I think the government will do well to either build in safeguards into the law or clarify truly the intent of the law which lays down certain arrests. Interestingly, there is a constitutional safeguard that has already been provided in the famous D.K. Basu case, and this case was more in the context of powers of police officer under the Criminal Procedure Act and officers of the Central Excise, Customs and Enforcement Directorate. And the Delhi High Court has directed, or rather come to a conclusion, that the Service Tax Authority in this case clearly violated a fundamental principle that has been laid down by the Supreme Court in D.K. Basu's case. Interestingly, D.K. Basu's case is a landmark decision, and even the manual of the Service Tax Department prescribes that the D.K. Basu principles be followed before any arrest is undertaken. So despite a directive, they had gone ahead and undertaken this arrest.
All right, Mukesh, we will leave it at that. Appreciate you joining us here with your reactions on the order that's coming from the Delhi High Court, scathing order against the